Okay, everyone. So we'll begin in just a moment as more people are joining. But in the meantime, I just want to say to everyone, good morning or good evening, as you can tell from my background, perhaps good afternoon, depending on where you're based out of. My name is Yuriditsky, and I'm the head of intelligence of Scope. And joining me today will be Katherine, one of our senior editorial analysts, and I'll allow her to introduce herself more in depth. She'll be presenting today on the USA's Anti-Money Laundering Act of 2020 and its impact on the compliance industry. And as always, we're really excited to share with you our research, our thoughts and evaluation analysis on various topics that have to do with the compliance industry. And today is no different, but today is particularly exciting because it's a really major breakthrough for the USA, and it has a lot of interesting implications and, of course, nuances that are super important to delve into. As I won't be presenting, I won't get too much into details of myself, but like I said earlier, my name is Lev. I am the head of intelligence here. I have about 10 years of experience in geopolitical risk analysis and other forms of intelligence, both in academic and professional settings, as well as some field work with a couple years with the United Nations before I joined Scope almost exactly a year ago. I think tomorrow will be my year anniversary with Scope, so I'm also excited for that. So before I pass the mic on to Katherine for her to present to you, I would like to introduce Scope as a company for those who are familiar with us. So we are a Luxembourg-based company. Naturally, as you can tell, based on the two personalities that are with you today, we're also quite diverse in our locales. I'm based in Tel Aviv, where our intelligence division is basically headquartered, but we're spread throughout the world. We have analysts and teams working for the intelligence division really throughout the globe in all corners, including in Africa, in Asia, in Europe, in the Middle East. So we're quite diverse in that. And we also, of course, have offices in Luxembourg and Switzerland. We've been around for just over a decade now, and we like to pride ourselves on being a leading provider of enhanced due diligence support, as well as now ever-growing, because of ever-growing demand, ESG reputational assessments. And we do this in order to empower financial professionals to evaluate risk and drive business, and in order to comply, of course, with AML, KYC, and other anti-corruption regulations. So in the past decade that we've been working, we've managed to serve and continue to serve just over 200 leading financial institutions throughout the world in really major financial hubs, including, of course, Luxembourg, where we're founded out of, in Switzerland, Singapore, Monaco, Liechtenstein, and others. And we do so also in complete compliance with GDPR and ensure full confidentiality of our client's identity, as well as all sensitive information. And like I said earlier, based on the description of where we're located as an intelligence division, we pride ourselves on also being a very multinational team, which is important for many reasons, the least of which is not the background that it lends to our division and the capabilities that it gives us in analyzing the information that we analyze and providing enhanced insights, which is why it's so great to have Katherine with us today as an American-based analyst who really understands the matter that she'll be speaking about. So just getting some logistics and practicalities aside, letting you know that the presentation will be recorded and uploaded later for your convenience, and the slides will be shared with you in a PDF format. So I hope that helps you and is convenient. And without further ado, I'll pass it on to Katherine for her to introduce herself and begin the presentation.
Hi, thanks, Lev. As Lev mentioned, my name is Katherine. I started my career also about a decade ago, originally in security intelligence and a lot of geopolitical analysis work. I worked for a lot of top Israeli security companies, but now I'm based in the US, in the Kansas City area, and I made the shift to Scope about 4 years ago. And though I perhaps expected that it would be less exciting than my previous work, with geopolitical analysis and, security and all of that field of intel, the shift to business and financial intelligence has really been quite the opposite of that. I've very much fallen in love with the sector and the sort of endless opportunities for inquiry and how it rewards curiosity. In my previous roles, I had a lot of opportunities to work in various regions of the globe, focusing on various risks and intelligence in various regions. And I love how in this sector, it's no possibility of really clearly defining one region of the globe separately from others. It's an interconnected world, and you need to be able to respond and understand the intelligence needs of each area of the globe, even in a single investigation. So I really love that about the sector and about my position as an analyst and an editor with Scope. So we'll go ahead and dive right in. So our agenda for today is to look primarily at the US AML legislative history and background and how that's culminated in the new legislation passed in January, the Anti-Money Laundering Act of 2020. Although it was technically passed in 2021, it is AMLA 2020. We're going to look at what is contained in the legislation with a focus on three particular areas that are of interest to compliance divisions. And those are the Corporate Transparency Act, the foreign sharing and foreign reach components of the act, as well as whistleblower provisions, which is really a game changer, or we anticipate will have significant impact on compliance divisions and how they're forced to operate. We'll also look at the FinCEN enforcement tools, including a big bump in the tools they have to go after AML crimes, to go after money laundering crimes and other AML tools, as well as some significant increases in possible penalties for violators of these new and existing laws. And then we're also going to look at the challenges to enforcement of these new regulations, as well as anticipated legal challenges to the laws. Throughout the whole presentation, we're really going to be focusing on the impact to the compliance agency. I don't want to delve too deeply into sort of the nitty gritty of exactly, what agency is established here and what's the budget for this and, all of those details. I really want to focus on a broad picture of what trends does this indicate, what risks does this expose, and how do compliance divisions need to respond to this very significant new legislation. So the Anti-Money Laundering Act of 2020 is the most significant federal legislation in the United States since the 2001 Patriot Act. And it's been called a lot of things. It's been called a game changer. It's been called an overhaul in the US approach to money laundering and enforcement efforts. It really provides broad-ranging enhancements to reporting requirements, enforcement tools, and prosecutorial penalties. And given the recentness of the legislation, as well as a call for interaction between a lot of different government agencies, financial institutions, and even a lot of foreign entities, implementation is going to be a little bit slow, and the impact might not be measurable for some time, or the effectiveness might not be measurable for some time. We do anticipate that the impact on financial institutions is going to be felt immediately. And again, we do anticipate legal challenges on the grounds of data privacy and also on the grounds of states' sovereignty versus federal sovereignty in the United States, and also in terms of its sort of contradiction perhaps with foreign laws or laws of other sovereign states. This is similar to what's been faced by other AML legislation in the United States in the past. There's always a lot of legal challenges and also a lot of additional legislation to support and further define the legislation that's passed. So we also anticipate that. We anticipate, one, a lot of legal definition through the court system and the judicial system, but also a lot of further legislation to sort of bolster support and further define what's laid forth in AMLA. So a brief history, which many of you are probably very aware of, but I just want to get a solid foundation before we move forward. In 1970, the United States passed the Banking Secrecy Act. BSA has served as the backbone of US AML requirements, and has been really focused on reporting and record keeping in order to identify indications of money laundering, terror finance, tax evasion, other illicit activities. There were numerous challenges to the BSA when it was passed in the 70s, And many of those were elevated to the Supreme Court, as we anticipate will happen with AMLA. But in 1976, BSA was upheld by the Supreme Court, which reinforced the US access to those increased records, which were previously really in the realm of a privacy issue. And until the 1980s, even, there was sort of like a prolonged period of inaction in which financial institutions were sort of hesitant to get on board with BSA's reporting requirements. So it wasn't really fully adopted by a lot of institutions until the 1980s. I don't anticipate that will be the case with AMLA. I think that the requirements will be enacted much more swiftly, and that the decision to go along with them and the possible penalties for failure to do so will mean that there's not anywhere close to a 10-year gap before we can really say that this legislation has been implemented by the institutions and individuals that it impacts. The BSA has undergone several amendments throughout its history. Most notably in 1996, the introduction of standardized suspicious activity, or SAR, reporting. And then obviously in 2001, post 9/11, there was a legislation creating information sharing and identity verification, a lot of additional efforts to prevent terror financing that expanded upon the BSA. And AMLA 2020 is a significant modernization of that AML law. It will do a lot to sort of catch the US up with what the rest of the world is doing in terms of AML compliance. So the nuts and bolts, briefly, of the act. It was passed by Congress on January 1st, 2021, with just wide-ranging bipartisan support. It was included in the annual National Defense Authorization Act. So most of the legislation linked to it did not have anything to do with money laundering, but rather with defense. But it had very strong support, so it was included in this act as a way of pushing it through, making sure it got the support it needed. Donald Trump had threatened to veto it, but the support for the bill was so strong that they were able to secure the votes needed to pass to protect it from the threat of presidential veto. So it has a lot of really broad-based support in bipartisan circles. It really brings the U.S. into compliance with many requirements of the Foreign Financial Action Task Force, of which the U.S. is a member. And up to this point, it's faced a lot of criticism for maybe not necessarily being on the same page in terms of a global approach to an anti-money laundering program. And this legislation really does a lot to sort of get the US up to speed and to have them sort of join the ranks of a more integrated global approach. It also expands to include cryptocurrency. It doesn't specifically say cryptocurrency in the legislation, but it just specifies that basically any fungible instrument, anything that can be traded for one value and then retraded for the same value, that's going to be under the purview of the legislation. And it also makes a specific provision for the inclusion of dealers and other participants, such as advisors, in the antiquities trade. And this is only for antiquities. It doesn't yet include art dealers that aren't antique art dealers. There's a lot of overlap there. It's unclear how this might apply to museums or other entities that deal with antiquities. But it does signal sort of a shift and probably increasing trend towards widening the purview of BSA and expanding the definition of what is a financial institution. So we expect that art dealers will soon come under the full scope of BSA. That's sort of only a matter of time until that occurs. So another really significant part that I want to sort of linger on for a bit of the legislation is that it includes a definition of purpose for BSA. So it now finally says the reason for all of this reporting, the reason for all of this record keeping, here's what it means, here's why we need it, here's our goal with that. And it's the codification of a risk-based approach. So it essentially reinforces and defines a risk-based approach requirement for AML and CFT by institutions and other related parties. It amends the purpose of the BSA to include the goal of effectively preventing money laundering and the financing of terrorists by requiring financial institutions to establish risk-based programs. So up to this point, it's been very much sort of compliance by means rather than by results, but now it's taking a look saying you have to enact effective programs to do this. It's not enough to just, to have this number of SAR reports or to have, this degree of record keeping. You have to be taking a more risk-based approach to AML and doing things to ensure effectiveness, not just effort. So Scope has been engaged in that exact sort of risk-based assessment since, I guess, before it was cool maybe, or at least before this risk-based approach was really enshrined in law as the expectation for compliance divisions. And I think that as a company, we've really felt validated by the increasing shift and trend for regulators to require that exact sort of work. So an example is in political exposure. In our reports, it's always been the case that not all PEPs are the same. So the honorary consul of a small allied nation, might be given a lower risk ranking in our reports than the mayor of a mid-sized city. All other things being equal, that would almost certainly be the case that we would rank the mayor as, this greater political exposure, even though that mayor of a mid-sized city is going to be far less likely to be included in PEP databases. And an honorary consul would almost certainly be listed in PEP databases, but we just think that that does not take into account the real risk of corruption and fraud and other financial risks that are posed by an honorary consul, which is a very, can be not grant a lot of power or influence or any sort of connection between, actors of fraud and bribery, whereas being a mayor of even a smaller size city can really open up for a lot of corruption. So that's the direction it's heading. It's heading away from the sort of tick box compliance of, is he a PEP? Yes. Is she a PEP? No. And looking for actual real risk assessments. An example of a way that outside of AMLA that shift has happened is that in August of 2020, the Federal Reserve, the FDIC and FinCEN issued a joint statement that it does not automatically deem US public officials as inherent PEPs. So instead, it asserts that a risk-based approach should be applied to PEP assignment, and it says not all PEPs are high risk solely by virtue of their status. And so to see that sort of language coming out of the regulators is really affirming to the work that we do at Scope, and also really shifts a lot of the expectation on compliance divisions towards more robust and less automated systems of compliance, particularly with the higher net worth individuals or politically exposed individuals. So the next section of so now that we've gotten like the basics of the legislation and really its intent and the basic tenets of it, I want to talk about one component of it, which is the Corporate Transparency Act, which is basically a beneficial ownership registry. Prior to AMLA, individuals could incorporate or form US companies in basically every state of the country without having to disclose beneficial ownership data to the state or federal government. Now, that was a little bit different in terms of of those companies' requirements to the banks, because the banks have their customer due diligence requirements that require them to assess and determine beneficial ownership. That was solely on the shoulders of the banks and the federal government had no involvement in the collecting, verification, and compilation of those details. So the Corporate Transparency Act, as part of AMLA, requires certain corporations and LLCs to disclose beneficial ownership to the U.S. Department of Treasury's FinCEN, which will establish a non-public registry to track that beneficial ownership. It's the first federal legislation of its type. Reportable details, it must be for natural persons. So it has to find the ultimate beneficial ownership, not intermediary shell company ownership. It includes their names, date of birth, address, and ID number, whether that be passport, state ID, driver's license, whatever, because that's also a challenge with the US and that we don't have a federal ID system. The beneficial owner is defined as any person with 25% or more ownership and or substantial control. What substantial control is has not yet been defined, but it is that language is in the legislation. Existing companies have 2 years to report, but any new companies formed since the enacting of the legislation must report beneficial ownership at the time of incorporation or formation. So FinCEN may share the details contained in that public registry with law enforcement, with intelligence, with national security entities, as well as trusted similar foreign entities. So that also really represents sort of increase of their cooperation and sort of global approach to the AML under AMLA. And it also may share the information with financial institutions with the consent of the reporting company. So now compliance divisions can turn to FinCEN and say, I'm trying to onboard this company. We need information about their beneficial ownership. Will you please, disclose what's in your registry? Here's the consent of the company. So that will actually potentially really lift a lot of the burden on compliance divisions to determine those sorts of facts and bring a share of that responsibility onto the government. The lack until now of a comprehensive system of beneficial ownership has really long been a criticism of the FATF and other AML organizations and other nations. And the establishment of such a system has been a goal for US law enforcement for many years. But there are a lot of challenges to the implementation of this registry. One is that it's unclear how it's going to jive with CDD, customer due diligence requirements on banks. So it makes it clear that it does not eliminate the existing CDD role, but that it's supposed to bring it into conformance together. But it's unclear whether that means that the banks will no longer need to do that work and they will just be able to take directly from the FinCEN registry, whether they will be sort of a checking of each other. So FinCEN will do on one side, the bank compliance will do on the other side, or other financial institution compliance on the other side, to sort of come to a greater understanding of the beneficial ownership of the company. If that's the case, if these are simultaneous processes, then there's a concern for what happens when the information is contradictory. Or if information is absent from the FinCEN database, then what is the role of the compliance divisions to either resolve that discrepancy or that absence? So does this mean that the existence of discrepancies and absence means that it automatically triggers a SAR report? Will compliance divisions feel compelled to defensively terminate relationships because of potential discrepancies between their CDD procedures and what's listed in the federal due diligence, the federal beneficial ownership registry? So there's a lot of questions about how exactly that's going to play out. And then another challenge is, of course, up to this point, the formation and governance of companies has solely been within the jurisdiction of states in the United States. So requiring an element of that to be enacted on a federal level is probably going to receive a lot of backlash from people who really are, as there are many in the US, really trying to prevent the creep of federal control vis-a-vis the states' rights to control certain aspects of things that happen within their borders. So we can expect a lot of also attention on those two fronts. Tension in resolving between the banks and the compliance divisions, and then also tension between federal and state governments in the United States. Okay. Another quick note on the Corporate Transparency Act is who's included and who's excluded. It's basically for US registered corporations, LLCs, and foreign entities who are registered to conduct business in the United States. It has a lot of exceptions, including for larger companies like those with over 20 full-time employees or that report over $5 million in revenue. Also, certain sectors of business are excluded, and there are basically two reasons for that. One is many of these companies are already subject to more stringent reporting protocols. For example, publicly listed companies are dealing with a different level of reporting, and they all already have to disclose beneficial ownership. And then also it maintains the focus on these smaller entities. The focus is really on eliminating the possibility for shell companies and complex corporate structuring through very small LLCs and other sorts of organizations that in many ways slip under the radar. So in order to maintain that focus on these small companies and shell company activity, there are a number of exclusions from the beneficial ownership reporting requirement. The next and very interesting part of the legislation is the foreign sharing and the foreign reach. So for foreign sharing, foreign law enforcement entities can obtain details or SARs of US entities or personnel if the request is sponsored by a US governmental agency under AMLA. Also, financial institutions are allowed to share SARs in a greater capacity than they were before. So they can share with, it's a 3-year pilot program. I should point out to begin with, they're going to see how it goes, and they expect a little bit of kickback. So they want to be able to, not kickback, but backlash, because they want to be able to demonstrate its effectiveness in order to respond to potential criticisms for the loosening of the reins on who can share SAR reports. It's a little bit sensitive because of what happened with the FinCEN files when those, thousands of SAR records were released, and with just outstanding damage to the reputation of both U.S. law enforcement and the financial institutions who were exposed in those files. So loosening the reins on who can view and how you can share SARs is obviously going to make companies a little skittish, I think, and also financial institutions a little bit skittish because they understand the impact and the fallout that can happen. There are some limitations on it. The intention is to significantly improve how the international elements of a large or complex financial institution can communicate for the sake of maintaining effective compliance. They don't want a situation where one branch of a bank in X jurisdiction knows about all the suspicious activity of a client and they're unable to share it with Z branch in another jurisdiction in order to effectively assess the risk of their clients. But again, the downside of that is the potential for leaking of suspicious activity reports. And for that reason, there are limitations on it, such as that doesn't apply to branches of financial companies or foreign law enforcement in China, Russia, or jurisdictions subject to US sanctions. And again, that's a 3-year pilot program, which has a built-in option for an automatic 2-year renewal. So it'll be interesting to see how that plays out and to see if they're able to maintain the security and confidentiality of those SAR reports while also increasing the effectiveness of money laundering efforts, anti-money laundering efforts, that is. The other and more interesting, I think, just because of my geopolitical background aspect of this is the foreign reach component. The Act really expands on the authority of subpoenas as granted under the Patriot Act. So currently under the Patriot Act, if a foreign bank maintains correspondent accounts in the United States, those accounts are subject to subpoenas if relevant to investigations by law enforcement. However, AMLA expands those and just really sort of blows the doors wide open in saying that now the US is allowed to subpoena any relevant records at foreign banks with a correspondent relationship to a US bank or US correspondent accounts. So that means that it doesn't have to be related to the accounts specifically, the specific US linked accounts, but any accounts that they feel are relevant to the investigation or the matter at hand, they are allowed to subpoena. And on the one hand, the long-term effect of these comprehensive changes moves the US closer towards a sort of global cooperation. On the other hand, it also reinforces this really US-centric legal framework and sort of extraterritorial reach or attempted extraterritorial reach of the United States anti-money laundering officials. So it creates a situation in which there might be a lot of competing sovereign interests. I think US banks will certainly see the heat turned up in terms of increased exposure to investigation and prosecution under AMLA, but foreign banks almost confront a doubling effect since AMLA both increases the expectations for compliance provisions and reinforces and expands this very aggressive stance on prosecuting corruption and money laundering, even extraterritorially. So I think it'll prove problematic for a lot of foreign customers of non-US banks. It could present onboarding or marketing challenges as foreign customers seek to insulate themselves from the sort of long arms of US law enforcement. There's additionally an issue of contradictory sovereign laws. So you may almost inevitably will have situations in which US law says this bank must provide records, and the home country's laws say this bank absolutely may not provide records. It seems likely that many banks will choose to comply with US demands due to the high penalty for failure to comply with these subpoenas. It's $50,000 a day, and after 60 days, there's an opportunity for additional penalties to be sought against the bank for not complying with subpoenas. The US government can seize funds from the correspondent account in order to satisfy those civil penalties and other violations. So surely there will be financial institutions who maybe feel very brave or for whom the price of complying with those demands really outweighs the price of non-compliance with AMLA 2020. So legal challenges to this aspect seem pretty much inevitable, but also it will create a situation where foreign banks with US correspondent relationships are going to have to either reevaluate their correspondent relationships to determine if the exposure to the AMLA regulations and subpoenas is worth it, and also to make sure that their compliance is very, very airtight, so that even if they do face exposure to these subpoenas, they feel confident that their enhanced due diligence is sufficient to protect them from any implication of wrongdoing, even if clients within their bank may be subject to investigations. And some examples of how this has played out in the past, and we expect to see more examples like this in the future, would be, for example, PDVSA. In 2008, the US Department of Justice sentenced a Swiss banker to 10 years in prison for his role in the PDVSA corruption. There's Odebrecht in Brazil. In 2017, a US judge awarded $2.6 billion fine in a criminal corruption case. And there's 1MDB. US courts ordered Goldman Sachs and their Malaysia subsidiary to pay $3 billion in fines. And then also with FIFA, there was a Guardian article that described the FBI as winning the World Cup of fraud when they managed to successfully bring the scandal into US courts for prosecution. So there's already a very aggressive move from the US to prosecute corruption, even extraterritorial. And I think that AMLA really lays bare the intention to continue this aggressive and increase this aggressive stance. This is something that our clients really come to us a lot to resolve these issues. An example related to PDVSA is we've had very low profile Venezuelan subjects that seem to be very risk-free, but through our methodology, through our enhanced due diligence, we have really been able to draw a lot of connections between particularly family members whose either mother-child relationships, brother-sister, uncle-nephew relationships, where one of the members of that family is a PDVSA official and has been implicated in the US courts. So identifying that as an aspect of due diligence, identifying, it seems like this person might just own a clothing store in Venezuela, but turns out actually her son is being prosecuted in the US for his role in the PDVSA corruption. So it really highlights that need to make sure that your due diligence and enhanced due diligence is airtight, that you're really going after all the angles of investigation, outsourcing, be it to scope or others, to make sure that you've got the highest level, particularly for problematic jurisdictions such as Venezuela, politically exposed individuals, and then higher net worth individuals as well. So, and the third, we're on number 3 now. The third aspect of the legislation that's really going to be interesting and really impactful on compliance divisions is enhanced whistleblower protections. So there are elements of the AMLA whistleblower protection program that follow those that were established for the Securities and Exchange Commission, the SEC, under Dodd-Frank. That proved to be a game changer, the whistleblower provision in Dodd-Frank. I think that there are, like the number, it's something like 7 billion has been recovered as a result of whistleblower complaints to the SEC, and just a high number of rewards have also been issued to the whistleblowers for bringing corruption and criminal activities to light that have been successfully prosecuted. There is really just a huge uptick. I think the SEC whistleblower office receives tens of thousands of tips each year from every state in the country, and over 100 countries. And I think it's reasonable to expect that the enhancement of the whistleblower protections that exist in AMLA will be similarly, if not more, impactful. Whistleblower provisions in AMLA both increase the rewards and increase the protections. So there's now an award of up to 30% of the bounty recovered. Previous awards were something like 25% of the bounty recovered, and there was a cap of like $150,000. Another change is that awards are no longer discretionary, at least according to the language, at least what we think will be enacted. The legislation says that they shall be awarded for successful, if they meet the terms for reward, that it shall, not may be, given these rewards for successful whistleblowing reports. And there's also a number of enhanced protections from retaliation, professional retaliation. So they really, whistleblowers have just an increased incentive to blow the whistle. So the impact I think that this will have on compliance is that it's possible that this will create tensions in compliance divisions. It can have the effect of turning bank employees' interests, particularly a large number of frontline employees. So for example, in the SEC, the number of employees who are qualified or have enough information to be able to present a successful whistleblower case are very, very limited. When you get to different kinds of financial institutions, such as banks and other money remittance services, the number of employees with access to and transparency on potential suspicious action or criminal activity just expands almost exponentially. So you have this huge pool of frontline employees whose interests might be easily turned against the bank. These employees might be somewhat weaponized by law enforcement. And it might prevent them from reporting failures of compliance or suspicious activity internally, instead of hoarding that information and reporting it to authorities to receive rewards for the whistleblower statute or under the whistleblower statute. And then also they would feel a greater level of protection, professional protection, and feel more emboldened to do so. So this is a case where compliance solutions such as those that Scope provides can be really invaluable to avoiding this pitfall. You just don't want a situation in which a large number of frontline employees have visibility on money laundering exposure or other illicit activities that is unknown or opaque to the compliance heads or the C-suite. You really want to make sure that, as a head of compliance, as a manager, as part of the C-suite, that you have full visibility on the risk exposure of your existing clients and the clients you're onboarding, to prevent the sort of situation where your frontline employees, you have to be paranoid about whether they're spies. So there's also a lot of additional challenges in terms of corporate culture and making sure that you've got, you avoid that situation. But one of the ways you can really protect yourself against it is to make sure, again, that you've got this airtight due diligence process. So now that we've talked about those three, I think the three most interesting aspects, at least for compliance officials, we'll talk briefly about the enforcement tools, which are also very enhanced. The U.S. Treasury Department will serve as the focal point for AML enforcement and coordination. And in many ways, it will not replace, but increasingly share the burden on collecting information with financial institutions. So I think in a lot of ways that this legislation can appear scary to banks or scary to other financial institutions, but also I think that one positive impact of it is that it can potentially really ease a lot of the burden of record keeping and the collecting of information, the reporting of information, the more bureaucratic steps of money laundering. It really shares that burden with the banks in a way that hasn't been done before. It establishes an Office of Domestic Liaison with FinCEN that promotes coordination between interested agencies, banking authorities, other institutions, foreign institutions, again, creating just a whole system that is more in line with the recommendations of the FATF and just more in line with what's going on in the anti-money laundering directives in Europe, et cetera. It establishes AML and counterterrorism priorities, again, focusing on this risk-based approach. It establishes Treasury financial attaches, which will be stationed presumably in embassies or in foreign law enforcement offices to liaise with foreign intelligence. It establishes 6 financial intelligence units within the United States to cover 6 domestic regions. There will be a significant burden on FinCEN to enact these changes as they're envisioned by the legislation. And one of the things that it will have to do is to create a Bank Secrecy Act advisory group, which will bring together various regulatory and law enforcement agents, as well as from the private sector, financial institutions, trade groups, to discuss AML matters. This will focus on innovation, technology, information security, and confidentiality, all those concerns we talked about with, increasing the accessibility of SARS to, foreign law enforcement, as well as, foreign branches of banks and things of that nature. All of those concerns will be discussed there. And I think that this is really an outgrowth of the FinCEN files. And that concern, I think that really had a chilling effect on the relationship between compliance divisions and law enforcement in terms of trust. And so I think that the establishment of this Bank Secrecy Act advisory group is meant to remedy that or to prevent it from happening in the future, similar things to the FinCEN files. Maybe the most compelling element of the enforcement is the increased penalties for violations. So we've got increased civil penalties, criminal fines, imprisonment. We've also got a new level of violations that didn't exist previously for things like unauthorized disclosure of beneficial ownership information details from FinCEN. So that information didn't exist before, but now there's a lot of violations related to the confidentiality of it. It has repeat violators have harsher penalties. Designated officers of financial institutions can be subject to repay bonuses earned in relation to prosecutions. Egregious violations can result in up to 10-year bar from serving on boards of directors in U.S. institutions. There are imprisonments of up to 2 years, just various increases to the penalties for violation. Another interesting aspect is that it creates a prohibition on knowingly concealing or misrepresenting material fact to a financial institution. So it does serve or seek to protect banks from willful misinformation provided by their clients. It also makes it a crime to knowingly conceal or misrepresent information related to either source of funds, political exposure, or transactions of over $1 million, I think. So some of the challenges to the enforcement have been brought up throughout the presentation, but I just want to refocus on them here for a minute. Anticipated legal challenges. Again, the increased power to subpoena foreign banks is likely going to come under a lot of legal scrutiny. The constitutionality of such a measure will likely be challenged almost inevitably, probably by a foreign bank. Privacy concerns. This is just a perennial issue in the United States. The culture of privacy and corporate governance is really a sensitive issue, and one that just doesn't seem to go away, and is going to probably rear its head in legal challenges to AMLA. And then again, also maybe sort of unique to the United States, perhaps not, but this idea of the usurpation of states' rights to govern and organize and permit the ability to form companies. There are also implementation and enforcement challenges. So there's, again, a pretty extreme bureaucratic burden on FinCEN. Like there's a lot of new hiring that needs to be done. There's a lot of new committees and agencies that need to be established. These aren't, frontline enforcement agencies. It's not like the big guns, these are really just support agencies that are being developed. But still, it's a lot because there's an expansion of both what they're meant to accomplish and also the tools for accomplishing that. Coupled with this, there is no specific allocation of budget, which is certainly probably going to hinder the rapid implementation or the rapid effectiveness of a lot of these measures. And then again, the impact is likely not to be visible for some time due to that time frame for implementation. And also, since it's focusing so much on the effectiveness, how is that effectiveness measured? Is it measured in the size of penalties, the number of prosecutions? Ideally, I think that the effectiveness would be measured by a lack of money laundering rather than an ability to catch it and extract huge fines. So that's a challenge also to determine the effectiveness. So in conclusion, just to wrap up before we do a few questions, banks have been deputized by the BSA and subsequent AML legislation, but they've also been targeted. And this legislation is no different. On the one hand, banks and an increasing number of non-bank financial institutions have a very crucial role as partners of the US government and law enforcement in the investigation, prevention, prosecution of money laundering. However, on the other hand, and particularly in the wake of 9/11 and then again after 2008, financial institutions and their employees have frequently been the target of these investigations and prosecutions, and regulators are very actively looking for failures in compliance as well as willful violation of AML laws by financial professionals and institutions. And up to now, due to, it might be harsh to say it like this, but due to perhaps a lack of robust AML regime in the United States, there's been a view that there's these constantly shifting goalposts and that the expectations for compliance departments have not always been well defined. And AMLA definitely shifts these goalposts again, but significantly, the legislation also goes a long way to help clarify and define expectations for compliance professionals, and it seeks a better balance with financial services community, and then particularly with the compliance departments in that sector. So there is a lot of positive reinforcement of the sector's role in AML efforts, but that's also counterbalanced by more stringent penalties for noncompliance. Again, sort of maintaining this dual role of you're our partner, but you're also our target. This increased attention, the more scrutiny as a result of AMLA, I think that financial institutions just have to expect a higher volume of inquiries from regulators and law enforcement. These measures are coupled with significant increases in potential penalties. And I think that that has the added element of increasing the motivation of prosecutors to seek such penalties. And in addition to increasing the reputational fallout of such legal penalty, such legal proceedings, you know, these big fines get big headlines. So that's going to increase the bank's exposure. Certainly, it's all sort of this perfect storm of increased authority, increased tools, increased consequences that can really substantially enhance the exposure of banks to U.S. law enforcement efforts. And when you add to this the sort of shifting focus away from means towards a risk-based and results-driven AML process, I believe that compliance departments will really feel the impact of this, you know, both for the better and for the worse. But it seems clear to me that some sort of response is going to be needed. There's no way you can sort of just ride this out and hope that your current protocols are just going to slide by. There's going to need to be evaluation and reevaluation, for example, of correspondent relationships with U.S. banks, and also, you know, more salient to us at Scope, a real reevaluation of your enhanced due diligence practices. Are these up to snuff? Do these meet the expectations and requirements of the new U.S. AML regime? And so I think that that response is going to be felt on a few different fronts, both, you know, in compliance procedures, in company culture, in, you know, relationships and interactions between foreign branches of banks. The impact, I think, will be, you know, and likely has already started. And again, that's not just in the US, as mentioned before. Due to the foreign reach of the legislation, foreign banks will have to adapt not only to the increased expectations for compliance, but then also to this, you know, ever increasing extraterritorial focus of US anti-corruption officials. So also, just to reemphasize, the codification of the risk-based approach really conforms to industry trends. And enhanced due diligence is really increasingly critical in order to meet these regulatory requirements. I mean, in a lot of ways, these regulatory requirements aren't surprising, and they're nothing new, and banks have already sort of, you know, enacted these sorts of enhanced due diligence for their own purposes, but now it has the added element of, you know, not only being beneficial for, you know, reputational or other reasons, but very specifically just because now it's flat out required. So they're going to have to, you know, face these increasing expectations regarding the effectiveness of their AML measures, in addition to their means of completing those AML measures. So I think that is pretty much it for that. And I'm ready for questions. I hope you have some.
Thank you so much, Katherine. That was really interesting and really necessary to hear. And I really liked all the points that you touched on, of course. We do have some questions. So we actually just got one from one of our participants, and he's asking, when is AMLA actually expected to come into force?
So certain aspects, there's sort of a sketchy timeline, not sketchy, but a variable timeline depending on certain elements of it. For example, beneficial ownership, that starts immediately. The reporting of beneficial ownership for new companies, but for existing companies, there's this grace of 2 years. I really can't provide a lot of, you know, legal advice specifically about like, oh, when do you have to have this nailed down by? It's not very clearly always outlined in the legislation, and probably a lot of it in the absence of those specific timelines, like, oh, starting from now, or, oh, you know, within 2 years. It will be as a response to the establishment of these additional positions, agencies. But as far as I know, a lot of the elements are already active. And then others have sort of grace periods for us to catch up. Important to note that none of it is retroactive. So this doesn't, none of these provisions can be applied retroactively prior to January 1st, 2021.
Right, thank you for that. And for our participants and for audience members, we have some questions already, but if you have others, then please continue to type them either in the QA or in the chat, so I will read them out. But we have one asking, if no budget or ability to allocate extra resources is provided by the legislation, how can we expect it to be meaningfully enacted?
This is actually something that's talked about quite a bit, you know, like what's sort of, a lot of it's very symbolic or maybe even idealistic. But the language supporting the allocation of resources really, resources and money is within the legislation. You know, specific budget, specific numbers aren't given, but it gives the agencies a mandate to enact these changes. And also, like I mentioned at the very beginning, we anticipate, you know, sort of additional legislation to support the enactment. So probably specific budgets for specific aspects of legislation will be enacted as the legislation, either, you know, federal legislation or just within the agencies themselves establish these elements to enact the legislation. So I assume that financing will not necessarily be a problem, but the exact mechanisms of how it will be financed just really haven't been established yet.
Okay, thank you so much for that. And the next question we have right now is, will the significant legal challenges that you mentioned dismantle the legislation?
I don't think so. I mean, for me, it's difficult to look at this idea of the competing sovereign law, for example, that you get with the foreign bank situation with the correspondent relationships. I think that will be difficult to challenge. But I think the overwhelming bipartisan nature of the passage of the law indicates that it really has broad support. And also, I think that the Supreme Court is likely to uphold it wherever possible. Again, there might be some points in which it just can't uphold it, or it has to scale back or redefine. But as it did with BSA provisions, which were similarly sort of jarring to the privacy and corporate governance culture in the US at the time in the 1970s, it was upheld then. And I think that AMLA will similarly be upheld now by the Supreme Court.
Okay. And last question I see right now is, so far, has there been any response from foreign financial institutions as of yet, whether positive or negative?
I don't think so. It's sort of a little early. Like I said, I anticipate some foreign financial institutions will eventually bring legal claims, but it takes time for those, you know, to actually occur, for those subpoenas to be submitted, for them to react to them. So I don't think that will be immediate. And I think that foreign financial institutions are definitely not necessarily fans of the sort of aggressive extraterritorial reach of the United States. They're not necessarily issuing statements on it. And that the criticism of that is really more, occurs more on maybe a diplomatic level or a policy level, a more political stage, the criticism of this US reach. So again, that also hasn't necessarily happened that I know of. You know, I don't think people are looking, you know, for opportunities to really vocally criticize the US always, but they're, you know, so I think that it will happen in response to certain situations. I don't think people are just looking at the legislation and then going ahead and calling it out. But I think that the faces of US, what's seen as overreach or really aggressive extraterritorial policies, they always face a lot of criticism, but I don't think necessarily from banks or financial institutions who don't have any interest in really, you know, coming out swinging. I could be wrong. It could be that they will really, because they feel threatened by or want to sort of bolster opposition to the legislation, that they might do such a thing, but I haven't seen it yet.
Okay, thank you for that as well. I see no more questions at this time. Kathy, if you go to the next slide, please. I first off want to, again, thank you everyone for participating. Like I said earlier, we will share this, share the recording of the presentation on our website, and we'll be sending out to all of you who joined us today. We'll send you the slides as well, so you have that. And if you have any questions at all, you can reach out to us directly. We'll provide our email as well. And I also want to take a moment to introduce our brand new portal. We just established this over the past couple months, and we invite everyone to log in, and through this you can get more information about us as a company, about our offerings, our services, and our expertise. And the URL is right there for you as well, and you'll receive that in the PDF that we'll be sending out later. And again, it was an honor to host everyone here. And Katherine, really thank you so much for taking your time to put this together, and for your research, and for sticking around to answer questions. For me, it was really fascinating. I'm a geek for these kind of things, so it was really enjoyable to listen to it all. And thanks again.
Pleasure. Sure thing.
Take care, everyone. Have a good rest of your days.
Bye.